There's certainly scope, and sensible modernisation is really important and will be really helpful, particularly as the country's demographics change further.
The Law Commission has made some recommendations for how to improve the law in this area. One of the recommendations which leaps out is the suggestion that the capacity test that should be applied in testamentary cases is the test in the Mental Capacity Act. Having a single test and having clarity is always better in the law.
People who are in the early stages of dementia, even if they have capacity, may nevertheless be extremely vulnerable to influence from others. So I welcome medical practitioners wading into that area that perhaps they didn't before.
Not all clients will be vulnerable because they're elderly. There may well be all sorts of other potential vulnerabilities. It's so important for us as advisors to look out for them and to listen to the alarm bells when they start ringing. I think certainly there's scope for development. The Mental Capacity Act 2005 test for testamentary capacity should be adopted in place of the Banks and Goodfellow tests.
Legal cases cost an enormous amount, and the whole aim of this is to prevent litigation and prevent squabbling over your estate when you've gone.
You can never completely eliminate the risk of a challenge being made to a client's will after their death. All you can do is your very best to minimise the chances of that happening.
The other recommendation, which I think is an important one, is a suggestion of a code of practice for how a testator's capacity should be assessed at the time of making the will.
STEP already has one, actually. It would certainly give some guidance to practitioners who don't make wills on a regular basis. It might help with unregulated will writers. I think it should certainly include guidance as to seeing testators and testatresses on their own. And in relation to capacity, it seems to me that it should contain guidance as to some red flags that might encourage a medical report.
Most of the wills that I've dealt with in contentious wills, the solicitors try to ask potential beneficiaries to leave the room, but sometimes the testator or testatrix ask that that beneficiary stays. And I don't know, but I think that if I were a solicitor drafting wills, I think I would insist that the new beneficiary leaves the room.
Certainly, we're very familiar in the context of children with the idea that sometimes adults or people who want to abuse them will groom them in the sense of getting close to them, winning their trust, and then moving in to take advantage of them. And of course, exactly the same must apply with determined criminals who want to defraud older people as well. Exactly the same mindset has to apply to that as it does in the context of child protection, which is to be vigilant and to be on the lookout. Not to let that totally dominate your attitudes and behaviour so that just makes life miserable for everybody, but just to be sensible and look out for any behaviour that puts you on guard that there might be something slightly amiss.
The Law Commission did recommend that it should be easier to establish undue influence, and I would really warmly welcome the introduction of the law that would do that.
What I'd really like to see is increased recognition in the law of the vulnerabilities that occurred during the twilight period. Capacity has not yet diminished to such a degree that it's crossed the black line that the law provides us with.
Maybe the approach isn't to draw a line at all, and that there's a spectrum of places that people can be at within this twilight zone, and to have a more flexible host of approaches that can deal with specific issues.
How the law finds a way through that recognises on the one hand their autonomy and rights as an individual to make their own decisions whilst protecting them from the bad motives of others is really difficult. Of course, the end result is there are just huge backlogs in lots of areas, the deprivation of liberty safeguards being an absolute obvious case in point. So I'm not sure we've really served older people all that well, and I think that puts a lot of responsibility onto practicing lawyers to try and do the right thing. good professional judgment in the end is absolutely key.